me, I'm Brooke. I'm a supervisor at the Metzger firm. And this is Rachel. She's also a supervisor at the same firm. So in our practice, obviously, we often have to call kids to testify at trial. It might be to test their credibility or their truth competence. It might be to show that they have a positive relationship with their parents, or it might be to provide additional details of their stories that the DI conveniently left out. And we're here today to talk to you about a couple cases where the parents were prevented from calling the child to testify. And those cases are Jennifer J. and Daniella G. The county and the Minors Council, they're going to use these cases against you as weapons, so we're here to help you get ready to fight against them. So, show of hands, have any of you encountered a situation where you've been prevented from calling a child to testify? Anybody? Sue, yeah. And Donna, yeah, it probably will happen to a few of you in the coming months or so, especially since Genealogy just came out this year. So now you'll be ready to deal with it. This is really a developing area of law. We searched far and wide to try to find case law in this area, and there's really very few cases. So, but we'll share with you what's currently out there. Okay. So we'll start with the parent-friendly case, and that's Amy M. It's from 1991. In this case, the trial court did refuse to allow the parents to call their son to testify at the adjudication, and the Court of Appeal said this was a violation of due process and reversible error. Amy M. is still good law, but it has been distinguished by Jennifer J. and Daniella G., which we'll explain. Okay, the facts. This case was about an 11-year-old girl named Amy. She came to the social worker's attention when she told someone at school that her dad sexually abused her. She was detained the next day, and a psych eval was immediately ordered. That 7:30 was done by a court-appointed psychologist named Dr. Sherwood, and after evaluating Amy, Dr. Sherwood got a little nosy about her 8-year-old brother, who was still living with mom and dad, and that was Michael. The evaluator thought that Michael might be sexually abused by dad also, so the court decided to detain Michael from his parents too and order a psych eval. The first amended petition on this case had a B, C, and D count for Amy, and then for Michael it had just a C count and a J count. It's worth noting that on appeal, the agency actually conceded that they did not have sufficient evidence for the J, so mainly our focus is on the C. The trial on this case lasted several days, and Amy herself actually testified for 8 hours total. And she explained in gruesome detail about the sexual abuse, how it started when she was 5, when she would take a nap in the middle of the day, dad would come into her room and do some horrible things. She also testified that her guinea pig Molly was telling her all these things that were happening, and that the guinea pig threatened to kill her if she disclosed, and she claimed that she saw the guinea pig on the shelf during the testimony, which is why I have that menacing guinea pig on the slide. So clearly she was hallucinating some of this stuff. Dr. Sherwood testified that she was having PTSD and hallucinating because of the sexual abuse. Okay, so what about Michael? That's our key player here. The parents asked to call him to testify next because there's a C count for him. Minors Council objected, saying that his testimony wasn't necessary, quote, given the allegations, the nature of the allegations, which doesn't really make sense. There's a count against him. And the court said, let's wait and see what the evaluator has to say about Michael, then I'll decide whether to allow you to call him as a witness. Parents Council also asked that they have their own evaluator talk to Michael, and the court said no. So what did the 7:30 evaluator say about Michael? She testified that when she first met him, he appeared very relaxed and casual and like a normal 8-year-old boy. However, she did some psychological tests over a 4-hour period, and according to the evaluator, these tests revealed some psychological or some indications of psychopathology and an extreme risk of mental illness. So based on Michael's responses and his drawings, the evaluator felt that he was insecure, he was withdrawn, depressed, he had an unusual level of inferiority, he showed signs of a thought disorder and couldn't perceive reality correctly, and he also didn't seem to show any interest in seeing his family. Dr. Sherwood concluded that he didn't have many positive experiences or emotional connections at home, and that mom wasn't very empathetic toward him. The evaluator testified that mother had shown poor judgment in protecting Amy, so mom probably wouldn't protect Michael either. Based on all of this, she formed the opinion that he had suffered emotional damage and was at risk of further emotional damage if returned to the parents. There you go, there's your C count. The parents later had their own expert testify, and that expert disputed the validity of Dr. Sherwood's tests, the validity of the conclusions that she drew, and their expert indicated that any psychological distress that Michael was having was actually due to his removal from the family home and not due to any abuse or neglect. So let's turn back to the 730 evaluator. When it came to her opinion on Michael testifying, the evaluator said that Michael was under significant psychological stress, was repressing fantasies, was frightened, and was concerned about what he might say. And she believed that Michael would suffer additional emotional harm if he testified. At this point, the court did a sort of balancing test, comparing the value of Michael's testimony, his anticipated testimony, and the potential harm that the testimony could cause. And based on this, the court said, no, I'm not allowing you to call Michael to testify. The court ultimately sustained the petition as pled and removed the children from the parents. The parents appealed and argued, among other things, that their due process rights were violated when the court did not permit them to call Michael to the stand. And the Court of Appeals said, you're right, you were denied due process. And although they affirmed as to Amy, they regretfully reversed and remanded as to Michael for a new jurisdictional hearing. In its analysis, the court discussed the parents' rights that are affected. This is what we're fighting for here. The court said the fundamental rights are implicated in dependency proceedings, and they cannot be abrogated with impunity. Dependency proceedings are designed to protect children, not to prosecute parents. We're dealing with the right to care, custody, and control of one's child, and this is a basic civil right, and it is protected by due process guarantees. In particular, parties in a dependency proceeding do have a due process right to cross-examine and confront witnesses. So with these general concepts in mind, the court had to decide if it really mattered whether Michael testified or not. The only counts regarding Michael were the C and the J. And as I noted, the agency conceded no basis for the J. That idea is kind of called into a question, just be aware, by a 2018 case called InReDB, but we won't really go into that because for this appeal, all we're dealing with is the C. As I mentioned, the basis here for the C count at the trial level was obviously the 730 evaluator's testimony of Michael's mental condition and her belief that it was caused by the family atmosphere. If the parents had been allowed to call Michael to testify, however, his testimony might have shown that he's actually a normal boy who loved his parents and wasn't being emotionally abused. The evaluator herself even said that at first glance he did seem normal, so his testimony could have given the court a chance to decide. Also, we have the issue of the dueling experts here. On the one hand, we have the 730 evaluator saying that there's significant stress due to the home conditions. On the other hand, we have the parents' experts saying no, any distress is due to being removed from that home. Hearing from Michael himself could have resolved this conflict here. So in sum, Michael's testimony was material to the issues being litigated. Not only this, but there's also no available substitute for Michael's testimony that could have satisfied due process here. There was no testimony from any prior hearing. There was no report containing Michael's statements that could have substituted for his testimony. And lastly, since the parents' expert wasn't allowed to examine Michael, he couldn't have used the statements as the basis for his opinion. The court then tried to determine, okay, so the testimony was material to the issues. Was there any other basis to keep Michael off the stand? No one has suggested that he was incompetent to testify, i.e. that he couldn't understand the difference between the truth and a lie. Also, no one requested that he be declared an unavailable witness under Evidence Code 240. Under this code section, they would have had to establish that Michael couldn't testify because of mental trauma resulting from a crime. And I guess the only crime at issue here was Amy's molestation. This wasn't discussed or addressed at the trial court level, so that wasn't a legitimate basis to keep Michael off the stand. And we'll just talk about that a little more later. So his testimony was material. There were no substitutes for his testimony, and he wasn't incompetent or unavailable. Did the court have any authority to exclude the child's testimony? The Court of Appeals said no. In Jennifer J., that court actually disagreed, which we'll touch on later. The court said that if the trial court was so concerned about Michael's testifying, they could have protected him by having him testify in chambers under WIC 350B. But this code doesn't allow them to just exclude the testimony altogether. The court also noted the stark contrast between how Amy and Michael were treated here at this trial. Amy had actually been molested, but she was subjected to 8 hours of testimony where she hallucinated and completely decompensated. But Michael, who had never been molested, was exempted from testimony. The court applied the harmless error test and concluded that error was not harmless beyond a reasonable doubt. And we have Judge LeBron James agreeing over there. The evidence before the court was sufficient to sustain the C count, but had Michael testified, they could have been convinced that the 730 evaluator was wrong, that she overstated or misrepresented the emotional harm, such that the court could have dismissed Michael's case. All right. So key points from Amy M. before we move on. Michael's testimony was material to resolving a disputed issue and could have changed the court's ultimate ruling on juris. And there were no substitutes for his testimony. There's no stipulation, no prior testimony, no statements in the reports about the issues that he was going to testify about. So moving on, briefly I want to explain that evidence code that I mentioned a couple minutes ago, section 240. It defines the ways in which a witness can be found legally unavailable to testify, and the court in Amy M. said it hadn't been established. The relevant subsection for us is 240A3, and it says that a declarant is unavailable as a witness if they are dead or unable to testify due to physical or mental illness or infirmity. And subdivision C expands on this by further explaining a way in which a person can be found unavailable under A3. It requires that the person was the victim of an alleged crime, that the person was physically or mentally traumatized because of it, and that the trauma caused them to be physically unable to testify or unable to testify without suffering substantial trauma. And this subdivision actually requires expert testimony to establish unavailability. So you might be thinking, great, county and minors council have to have expert testimony to prove that the kid shouldn't testify. Unfortunately, that would be wrong. Under Jennifer J. and Daniella G., the requirements of section 240 do not need to be met in order to keep the kid off the stand. Also, another code section I mentioned that's important is WIC 350B on in-chambers testimony. Sometimes we'll be arguing against in-chambers testimony, but other times it can be a great tool for convincing the court to allow the trial testimony to happen at all. It's a safeguard if the court is really concerned about how the testimony is going to affect the child. And there's 3 different ways, circumstances that can exist that will justify in-chambers testimony that's listed there. Also, you can have in-chambers testimony at a 2.6, that's that subdivision below, has the identical language. Okay, so then comes Jennifer J. On the heels of Amy M. was Jennifer J., which came down just a year later from the Court of Appeal. The court in this case distinguished Amy M. and held that the court does have discretion to exclude a child's testimony to avoid psychological harm to the child. It's kind of a bummer, but as you'll see, based on these facts, the ruling kind of makes sense. You should note that although this case was about a contested 2.6, its holding applies to other types of hearings as well. Okay. All right, the facts. Jennifer and her siblings were detained from the parents because mom's boyfriend sexually abused Jennifer's older sister. We can't really escape sex abuse from any of these cases today. The parents were given a year of FR, couldn't really get it together, and 2 years later we're at the 2-6 Rex adoption. At that point, Jennifer's 7 years old, and the reports were saying that she was ambivalent about whether she really wanted to keep ties with her parents. Parents set the 2-6-4 contest. We again have an expert. Clinical psychologist Dr. Shipman was retained as an expert witness, and she testified about visits and parental bond with the 2-6, and she had strong opinions, at least about Dad. Three weeks before the 2-6, Dad had asked the court to appoint an additional expert to do a bonding study, but that was denied, and that denial was upheld. So at trial, Dr. Shipman testified that it would be detrimental and very upsetting for Jennifer to resume visits with her dad because Jennifer was picking up subliminal messages from Dad that they would be together again. And the expert felt that this caused her a lot of guilt and confusion. And she strongly felt that although Jennifer and Dad were bonded, she said this bond's negative, it's a bad bond. It doesn't appear that she testified at all about Mom, or if she did, the Court of Appeal didn't mention it. The Parents' Council said, we want Jennifer to testify at the 2-6. They said, she's going to testify that she's bonded to us. She wants to continue seeing us. Minors' Council objected, and counsel's rambling and nonsensical objection is quoted on the slide. Counsel seemed to claim that it would be traumatizing for Jennifer to have to answer these questions about adoption and that severing parental ties would be too hard for her to understand the difference between being adopted and not being adopted. As you all know, we occasionally call children to testify about these exact things at a 2-6. I know that I have. However, Mom did offer she proffered a stipulated testimony as an alternative to having Jennifer actually testify. The stip contained the following statements: that Jennifer was bonded to her parents, that she wanted to continue contact with them, and that she did not want to be adopted. Father's Council agreed to the stip, county and minor did not. The trial court sustained Minors' Council's objection to Jennifer testifying, so she didn't testify, of course. However, it seemed like they kind of accepted the stip anyway, despite the objections. And this is the key fact in this case. The court said, I'm going to take into consideration that Jennifer is bonded and would wish to have contact with her parents. And no counsel objected to that statement. Later on in its ruling, the contested 2-6 as a whole, the court said, although Jennifer was not allowed to testify here, I have considered the fact that I believe if Jennifer were here, she would say she wanted to be with you, that she's bonded to you, to both of you, and you in particular, Father, and that she would not want this adoption to occur. Notice that the court's statements during this trial encompass the entire contents of the proffered stipulation. That's relevant. But then the court goes on to say that despite this bond, that if parents hadn't established any exception to adoption, it ruled that the children would not benefit from continuing a relationship from the parents, and it terminated parental rights. Both parents appealed, and what's interesting is that only Mom argued on appeal that the court erred in not allowing Jennifer to testify. Court of Appeal affirmed, holding that in a proper case, the court may refuse to require the attendance and testimony of a child who is the subject of the litigation. And the court can do this even if the testimony is relevant, even if the child's competent, and even if the child is legally available to testify. I'm going to skip this next slide. So the court notes in its analysis that Jennifer's testimony was relevant. Under 2-6 subdivision H1, the court does have to consider the child's wishes at the 2-6 hearing. Not only that, but of course Jennifer's wishes were relevant to the beneficial relationship exception, C1B1. Further, the court notes that Jennifer J. was found neither incompetent to testify nor unavailable under 240, same as Amy M. So the question is, did the court have the authority to exclude the child's testimony? Mother said no. The AMM just ruled on this exact issue a year prior, and they said there's no basis. The Court of Appeal says, well, maybe there isn't any explicit authority yet, but they said the trial judge does have the discretion to exclude the testimony based on the overriding objective of dependency to preserve and promote the child's best interests. So that was their excuse. Here's the rule from Jennifer J. Jennifer J. couches it as a three-part test. The court has the power to exclude testimony of a child where the child's wishes can be directly presented without live testimony. The issues to be resolved would not be materially affected by the child's testimony, and it's shown that the child would be psychologically damaged by being required to testify. The court did note that child testimony should only be excluded after a careful weighing of the interests involved. And then they talk about AMM's discussion of fundamental rights. As to psychological damage, the court claimed that their review of the entire record revealed that the trial court had kept her from testifying because they thought it was damaging to her. And they cited minors counsel's objection. I think it's a pretty weak showing on the psychological damage end. What's important here is how Jennifer J. distinguishes Amy M. Jennifer's testimony would not have assisted in resolving a disputed issue, unlike Michael's testimony and Amy M. The facts the parents sought to establish here, the bond, the desire for continued contact, the desire not to be adopted, they were accepted as established by the court. The court acknowledged all of these things. They're not disputed. In Amy M., Michael's feelings were actually in dispute. Also, even if Jennifer had testified, it wouldn't have changed the court's ruling anyway. The crucial factor in the court's decision to TPR was not Jennifer's bond, it wasn't her wishes, it was whether she would benefit from continuing the relationship. The court said that regardless of this bond, there was still insufficient evidence of benefit, and also Jennifer couldn't really testify about that anyway. She didn't have personal knowledge. So again, different from Amy M, where Michael's testimony could have resulted in a dismissal. Lastly, the court noted here, at the end of the day, it's all about balancing. Requiring Jennifer to testify would have caused psychological stress, and the possible benefit to be gained from her testimony would not warrant the injury it would cause. Her testimony was of little use. So if you have a case where the child's testimony is material to a disputed issue, argue that the balancing weighs in your favor.
All right, so that leads us to Daniella G. Daniella G explicitly extends the rationale from Jennifer J to the adjudication and disposition hearings. And just as a reminder, Jennifer J / Daniella G provides an alternative mechanism to Evidence Code Section 240 to limit testimony at the adjudication and the disposition hearings. And beyond that, there's actually, unfortunately, dicta in Daniella G that says Jennifer J's logic isn't limited to just the 2-6 or just the adjudication or just the disposition. It can basically be applied to any hearing, so that's something to look out for. Daniella G was a case that came out this year, 2018, and I'm going to be talking a little bit of crap about some of the attorneys in the case. It's from San Francisco, it's not from here. So, Daniella G. So, in April of 2017, the stepdaughter told the maternal uncle that she was upset because stepfather was in the bedroom with Daniela. The maternal uncle then goes to the bedroom door and hears Daniela say, "You need to put your clothes back on." He then hears father respond, "Come on, mommy, give me a massage." I don't know what kind of family this is. That probably wouldn't be my reaction. I would probably try and get into the bedroom, but he doesn't do that. He calls the mother, tells her what's going on. Mom rushes home. She knocks on the door. "Hey, what's going on, guys?" Dad comes over. He unlocks the door, gets back into bed. He's like half clothed, and according to the mother, Daniela was also in the bed and, quote, looked afraid. Daniela at this time was 8 years old. The stepdaughter was 13. So then mom later finds a note that was authored by the stepdaughter where she expresses suicidal ideation. Mom confronts her about it. Stepdaughter says, "Yeah, your husband's been molesting me." Mom immediately takes the stepdaughter to the police, where she is then ushered into a forensic interview. At the forensic interview, the stepdaughter says that dad has molested her. It's been going on for 2 years. It's pretty bad. Daniela also participated in a forensic interview. She didn't disclose any abuse either to herself or knowledge of the abuse that was happening to her half-sister, but she did say, yeah, sometimes I give my dad massages. Both of the girls participated in physical exams, and there were no indications that sex abuse occurred. As background, there was a prior investigation by, it's called the agency, I guess, in San Francisco, by the agency in 2015, where dad was accused of viewing child pornography. He denied it. The appellate court is silent as to what happened with that referral, but this is not the first time that sex abuse issues have been brought up in this family. So in May of 2017, agency files a petition under both 300B and 300D alleging that Daniela is at risk of sex abuse due to the bedroom incident coupled with the sexual abuse of the stepdaughter. Agency also files a petition as to the stepdaughter, so we have petition for stepdaughter, petition for Daniela. Agency recommends sustaining Daniela's petition, closing it out with a family law order to mom, who is in the process of getting a divorce from the dad. And then, for some reason that's totally unknown, the agency withdraws the petition for the stepdaughter prior to the adjudication on Daniela's petition. So at this point, we now have a petition for Daniela, no petition for the stepdaughter, but the court appoints the stepdaughter counsel anyway. So I don't know what was going on. It was kind of a weird, just factual scenario. So at this point, given this set of facts, what would you guys do? Is there any additional information that you would want? Are you filing any motions? Do you guys have any ideas?
Yeah, just kind of on the Title 20s on the related case, like why did they withdraw the petition?
Yeah, for sure. Anything else? Okay, so some of the stuff that we...
Don't we want a 355, the stepdaughter?
Exactly. That's a huge point, Sue, and the appellate case is totally silent as to any 355s that may or may not have been filed, so I'm just going to assume they weren't filed, which is a huge issue because now we have these non-party statements coming in. So that's a big issue and one of the really important things. Probably you'd also want to subpoena the forensic interviews, the videos, get the transcripts if you're wanting to admit those into evidence, and definitely object to that non-party getting an attorney. I mean, it's just so bizarre, and there's no indication in the record that Dad or anyone else ever objected to that. So this non-party child had an attorney and got to participate in Daniela's entire trial, which is just bananas to me. So I left this blank so you guys couldn't cheat and look ahead and give me the answers for the last slide. So what actually happened in Genealogy, father subpoenaed Daniela to testify. So then in response, Daniela's counsel filed a motion to quash the subpoena based on Evidence Code Section 240, along with Jennifer J. So this minors counsel is saying, I don't want Daniela to have to testify, number one, because she's unavailable under Evidence Code Section 240, and number two, under Jennifer J. Daniela's counsel also filed a motion requesting that Daniela's statements in the report and in the forensic interview be admitted under the child hearsay exception, aka Cindy L. So if you guys have been to some of the prior trainings that I've done on Cindy L, Lucero L, it is still alive and well, and you're still going to be dealing with these issues in the cases that you're dealing with today. So what happens next? Dad's attorney also subpoenas the stepchild. Stepchild's counsel is not as motivated as Daniela's counsel. They don't file a motion. Instead, to prevent testimony, instead the counsel just argues that the stepdaughter was experiencing PTSD. She was, quote, very vulnerable. according to the child needs and adolescent, or child adolescent needs and strengths assessment. Has anyone ever heard of that? CANS? No? Okay, I never heard of it. I looked it up. I think it's similar to our MAT assessment. So they had someone go through and assess the children essentially in the same form as a MAT assessment. So then we get to the trial. 2 social workers testified. They both said it would be, quote, extremely dangerous for Daniela to be forced to testify because of her age and the nature of the allegations. I personally think this is totally bogus because the social workers are essentially saying, number 1, she's a child, number 2, we're alleging sex abuse, so yeah, like, let's just not call her to testify. Social workers also testified that it would be detrimental for her to have to see and testify in front of the dad. So alarm bells should be going off to you guys at this point regarding Brooke's point earlier about in-chambers testimony under 350B. Again, dad's counsel kind of dropped the ball on this. He never asked for it, he or she, they never mentioned it. It wasn't ever proffered in this case. So at the adjudication, the court admits all of the reports, the recordings of the forensic interviews of both of the girls, the CANS assessment of the girls, and a letter from the clinician who had done the CANS assessment. This letter was actually procured by stepdaughter's counsel. So just a tidbit for you guys, I know I get frustrated when I'm dealing with these activist minors counsel, so it's kind of nice to see other people have to deal with this too. You know, this was a minors counsel who was going out of their way to get this information and give it to the court. What does dad do in response? Honestly, not a lot. The only evidence that he submitted was the transcript of Daniela's interview. He didn't call any witnesses, dad himself didn't testify, that's all dad did. The court ruled that neither of the children was going to be required to testify. Court, of course, sustains the sex abuse allegations, dad appeals. So on appeal, dad made 2 arguments. Number 1, the court made a mistake by not considering having the girls testify in chambers. And number 2, that there was insufficient evidence that either of the girls would be traumatized if they were forced to testify. The dad brought up some arguments that Brooke talked about earlier in terms of violation of due process, right to confront and cross-examine witnesses. And we are on appeal, so the standard of review is abuse of discretion. Appellate court easily does away with the testimony in chambers argument. And they were like, yeah, Dad, this is the first time you're bringing this up. No one ever asked the judge to take that in chambers testimony, so you forfeited and waived that issue. We aren't even dealing with it. So it kind of begs the question, could this entire case have been avoided had father's counsel asked for in chambers testimony? So like Brooke was speaking about earlier, a lot of times we'll be arguing against that, but in certain circumstances you want to potentially argue for in-chambers testimony if that's what's going to get this child witness on the stand. And just be aware, waiver and forfeiture. Daniella G, the Court of Appeal, then kind of goes off on this little tangent and starts talking about Evidence Code Section 240. They say that father's appellate counsel spent a ton of time on Evidence Code Section 240. The court then talks about Evidence Code Section 240 and then is like, but we aren't even going to talk about this because the trial court didn't find the children unavailable under 240. They found them unavailable under Jennifer J. So just remember there are 2 different bases upon which a court can exclude child testimony, 240, Jennifer J / Daniella G. And they both have different requirements. So then the issue before the court was, did the trial court correctly rely on Jennifer J to exclude the children from testifying? Unfortunately, in this case, the appellate court said yes, it was appropriate for them to exclude the testimony. They again quote this language from Jennifer J about the overriding objective of dependency hearings, protecting and promoting the child's best interest. And again, they specifically say that Jennifer J's logic is not limited to the 2-6 hearing. They're saying we're expressly applying it to adjudication and dispose here, but it can be used at any point, at any hearing.
Before you go on, Rachel,
Yeah.
I feel like I've been on a long ride and I missed something. When is it that some professional, not a social worker, but somebody like who supposedly is trained to know about trauma, is required to tell the court, oh no, trauma has to be present or she'll testify? When, never anymore?
So Evidence Code Section 240, yes, it requires some form of expert testimony. With Jennifer J. or Daniella G, you just, the child or the county just has to show that there would be psychological harm. That could be via an expert, but it doesn't have to be.
And the social worker in this case, 2 social workers said because of her age and the nature of the allegations, it's not a good idea, so that's just all they need.
So I'll get into that a little bit more in a few slides, but it's honestly, it's not a lot, and it's kind of scary. Which is why we need to focus more on that first part of the test, is it material to a disputed fact, because I feel like you're right, it is kind of easy for the department and for minors counsel to show that this may be psychologically harmful for a child to testify.
Thank you.
Yeah, no problem. Any other questions? So what about due process? Father raised this argument on appeal. Daniella G, again, is just hammering away at what case law has said forever. Yeah, parents, you have some rights, but you don't have full rights. This isn't a criminal case. We're here for the protection of the child, and that takes precedent. So again, it's talking about weighing due process versus the protection of the child. So Dad tries to argue on appeal that Amy M controls, not Jennifer J, right? Amy M is the case we like, Jennifer J is the case we don't like. Court goes through, summarizes both of the cases, and says that this case is more similar to Jennifer J. Children's testimony here would not clarify any material fact that's in dispute. And yes, there is psychological harm to these kids if they would be forced to testify. So Daniella G talks about a 2-part test. Brooke talked about Jennifer J and the 3-part test. It's a little different because Jennifer J was a 2-6 hearing where the code specifically requires the court to take into account the child's wishes. And at a 2-6 hearing, one of the issues that is on the table is the child's wishes regarding adoption. Daniella G gets rid of that child's wishes portion of the test. So it's just a 2-part test. Number 1, is this information that we're trying to elicit on cross material to a disputed fact? That was also in Jennifer J. And 2, will the child suffer psychological harm if forced to testify? So if you're talking about a 2-6 hearing, you're going to be talking about the Jennifer J 3-part test. If you're talking about an adjudication dispo and probably any other hearing, you're talking about the 2-part test from Daniella G. Does that make sense? Okay. So the court goes through and analyzes the facts in this case. They say that Jennifer J requirement regarding is this material to a disputed fact was met as to Daniela. It's a closer recall as to the stepchild, but it's met as well. And unfortunately, Sue, this gets to your point, and I'll get into it more later, they said that they had no trouble determining that both of these girls would be psychologically harmed if forced to testify. What is super messed up about this case is in a little footnote, the court says, we aren't going to talk about how this test would be applied to a non-party because Dad didn't ask us to treat the stepdaughter different from Daniella G. So not only did Dad's trial counsel kind of mess some stuff up, but and I don't know, we don't have access to the briefs, all we have is the court's appellate opinion. But the opinion says, Dad's counsel didn't ask us to treat the stepdaughter any differently from Daniella G, so we're basically just treating them the same. But they did say that potentially in the future, we don't know if this 2-part test would apply to a non-party where the primary concern isn't the protection of that child. So it's kind of crazy and just an important note to distinguish, especially if you're dealing with these types of cases. You want to make sure you're making the argument non-party child statements versus party statements and make that distinction. So in terms of the evidence to be elicited through cross-examination, is it material to a disputed issue? So for Daniela, the court says, no, it it wouldn't have helped resolve any disputed issue. Daniela never said she was abused by stepdad. She just said, sometimes dad gives me massages. Dad never disputed that he gave her massages. And dad never denied any of the details about the incident when he was found in bed with Daniela. So the lesson here is to make sure that your client denies with specificity the allegations. So we will get into this a little bit more in a few slides. So in regards to whether or not, again, this is material to a disputed fact in terms of the stepdaughter, Dad argued that, well, heck yeah, this is important. The key issue here is whether or not I molested her. The court says, no, it wouldn't have helped resolve anything for the trial court because, yeah, you gave a general denial that you didn't sexually abuse her, but there was nothing to indicate that the father ever gave any alternate explanation or any version of his events. He didn't testify, he didn't challenge any of the specific details of the allegation. The second issue was the appellate court said that the credibility of the stepdaughter wasn't at issue. Dad, again at the trial court level, didn't identify any reason why he wanted to cross-examine her. He didn't identify any basis upon which he could hope to impeach her. So it's kind of unfortunate because I guess that kind of means in some respects we have to give up a little bit of our trial strategy and say, well, I think she may be lying because of this. Or I wanted to cross-examine her about this because, you know, she said one thing here and something else there. And Dad's trial counsel didn't do that. So he didn't give the court any reason why he needed to impeach this witness. Secondly,
but does that mean that they have to make an offer of proof? Is it required?
That's kind of what Daniella G looks like it's saying. This case is terrifying. I see her face, Sue, and I 100% agree. It's a terrifying case, and it's totally messed up. And it's just crazy kind of the way that Daniella G chips away so easily at a lot of the things that I feel like I at least take for granted when I'm in court doing trials. So the other issue is the court said, yeah, credibility is not really an issue here. Trial court watched the forensic interview with the stepdaughter. She was super credible, went into significant detail. You know, we basically believe her version of events. So looking, and Sue, again, this goes to your question, looking at the totality of the evidence, the appellate court said, yes, it would be psychologically harmful for these girls to testify. For Daniela, the court said her Kansas assessment said she was having difficulty processing her feelings, and that resulted in what appeared to be an indifferent response to everything. Dad's whole argument was, yeah, look at her, she's totally chill. Like, I can cross-examine her, it's not a problem at all. She's relaxed and, like, not stressed out. And then we have this professional saying, yeah, she's acting that way because she's, like, so emotionally scarred from what's going on. So that totally blew Dad's argument out of the water. Daniela was also reportedly having increased anxiety and eating more. So again, to me, this could describe like 99% of the kids that come through the system. But the appellate court said, yeah, that's enough to be psychologically harmful for her to have to testify. Regarding the stepdaughter, we could have what could be quote-unquote expert testimony. You had the social workers and a clinician who both opined that it would be detrimental for the stepdaughter to testify. Again, it's an important distinction. It doesn't have to be an expert opinion, but it could be for purposes of the Daniella G / Jennifer J test. So what does this look like in practice? It's kind of hard to tell because this case just came out this year in 2018, so I don't think we've seen a lot of these yet, but I think that we're probably going to have to be dealing with it a lot in the future, especially once minors counsel become aware that they can use this case at any point they like to be like, yeah, don't call my client, please. So when we're talking about defending against a request to make a child unavailable under Jennifer J or Daniella G, obviously you always want to argue, I'm going to skip to number 2, you always want to argue there's no psychological harm. Just throw that in there. But based on the case law from Daniella G, it doesn't sound like we're going to be super successful in arguing that most of the time. But I don't know. I think the big focus really needs to be on contesting and convincing the court that the information that we're trying to get from cross-examining this child is material to a disputed fact. You know, so things to think about. Why do I want to call this witness? How am I going to impeach them? What motive do they have to lie? Is this new information? Does it appear somewhere else in the reports? These are all questions that you can ask yourself to kind of formulate for the court your argument as to why this information matters, why it's material. You also want to make sure that you are denying with specificity, either through an interview with the social worker that your client does, through client testimony on the stand themselves. The question mark is if anyone else has any other ideas. Because basically Daniella G said that the general denial is not enough. Just generally denying the allegations and not giving any details, another version of events, a credibility assessment, it's not going to be enough to convince the court that you need to, that you deny these allegations and you need to call this witness. And then also I touched on this earlier, make sure that you're differentiating between party witnesses and non-party witnesses. Anyone have any questions?
I was just thinking about how many times I've read a jurist report and my client's interview is reduced to 3 sentences, and I'll say, wow, why didn't you talk to her? I did. We were there for an hour and a half. And then I have to go back in and ask the court for an order that the father's full interview be put in their next report, or that he be re-interviewed.
Right.
Because 3 sentences, unless they're saying no to everything, well, that should actually be no to everything.
Mm-hmm. And it's difficult because especially if we're dealing with sex abuse cases, a lot of our clients are going to have criminal charges pending. Maybe you don't want them to have an interview with the social worker. So you have to think about, okay, are there other witnesses I can call, other people I can get interviewed to get this information before the court? Or focus on the credibility assessment and ways to impeach the child witness. So yeah, it's kind of interesting. I feel like I've talked a lot in this presentation about how genealogy totally sucks and it's like eating away at our ability to put on witnesses and do trials. So we provided you guys with a little handout, just kind of some sound bites pulled from various cases that talk about why it's important for us to be able to call these witnesses, why this matters, information that you can provide to the court when you're making these arguments. So for the last 5 or so minutes, I wanted to do the hypo. So it's long, it has to be long because we need a lot of facts to be able to discuss these issues, but this is all very theoretical and I struggled to conceptualize it. So we pulled this from a real case, so if you recognize this case, don't talk about it. But if you just want to read through and then we'll have a quick discussion about the hypo. Have you guys had a chance to read through it? Yeah? Okay. So let's pretend we're minors counsel for a second. What would be your argument to prevent both of these kids, probably more likely Elsa, from testifying? Any ideas?
She made suicidal statements and this would be detrimental and would put her back and would cause psychological detriment.
We can use her statements from her interview, Elsa's interview, instead as a substitute.
Anything else? Yeah, it's, like I said, this is a real case, and minors counsel did file a motion to request to exclude Elsa from testifying, and saying exactly that, claiming she was suicidal, that she had this hysterical reaction. And so then, back to being a ladle, what arguments would you guys make against that? Make the argument, pretend we're representing mom, that Daniella G doesn't apply to this set of facts. What would you say to the judge?
Well, there's no evidence of psychological harm now.
Your child did say that it was a figure of speech at the time, and that she wasn't actually going to do it.
And this is a credibility challenge.
Yeah, totally.
And why are we trying to apply Daniella G to a B and a C? And why is there a C without any psych information?
There's also a D, but mom's not offending on the D. I don't care.
Yeah.
Yeah.
She had it coming.
Yeah, so it totally, I think we absolutely would need to make the argument to the court that it's a credibility assessment. You know, especially if she's been having these issues in school, she's acting out, you want to be able to call her to cross-examine her and attack her credibility. And then what about for dad? If you were dad, how would you defend minors counsel requests to have Elsa excluded from testifying?
There's an issue of contention whether she had sex or not, or she's saying different things at different times, so that's a material issue to be explored on cross-examination.
And then what would you advise your client if you represented dad at this point? What would you be telling him to do based on Daniella G?
Deny with specificity.
Deny with specificity.
Yeah.
Certain things.
Yeah. Exactly. Any other comments?
Does a denial with specificity mean that you have to deny each specific part of the allegation, or you have to be specific about your denial of each thing?
I think that's part of what's open to interpretation, because this is brought up for the first time in Daniella G, and the court basically said general denial's not enough. Dad didn't interview in the social worker's reports, he didn't deny any of the specifics of the allegations, and he didn't testify. So I have no idea what Dad's thoughts or opinions are on this.
So in a situation like this, you know, there's a lot of reasons why we wouldn't want to give the social worker free reign with our client. Would we ask for like an order saying the social worker can interview our client with us present, and then just like get what we need to get out of it off, or?
Yeah, I think that's a great idea. Or exploring alternative witnesses as well, as you know, is there a third party who could maybe shed some light back Dad's version of events at. Yeah. All right, thanks guys.